In real estate, a deed is a legal document that transfers ownership of real property, land and anything attached to it, from one party to another. It serves as proof of ownership and includes essential details about the property and the transaction. Deed types in California. A grantor may convey several types of deeds, depending on the form in which title is being conveyed. Not every conveyance comes with a fully warranted title. Following are the most common types of deeds used in real estate. Grant deed. A grant deed is used in California to convey title, which contains implied warranties that the seller, grantor, has the right to convey the property and has not otherwise encumbered the property. As with most deeds in California, grant deeds must meet specific requirements for recording, including formatting, and must be accompanied by a documentary transfer tax declaration and preliminary change of ownership report. Interestingly, the grant deed is the only deed in which you can convey property that you don't actually own. This is referred to as an after-acquired title. Here's how it works. A deed's a property that is actually owned by C. To be C then does a quitclaim of the property to A. This makes A's conveyance to be perfectly legal. You wouldn't be able to do that with a warranty deed. See if you can figure out why when you read about it next. Warranty deed. The warranty deed, sometimes referred to as a full covenant and warranty deed or a general warranty deed, contains the strongest and broadest form of guarantee of title of all of the deed types, and offers the greatest protection to the ownership interest of the grantee. The full covenant typically means 6 covenants are included. A covenant, as you may remember, is an agreement, contract, or written promise. The 6 covenants included in the warranty deed are: Covenant of season. Season means the estate is possessed by freehold, the grantor holds the title specified in the deed. Covenant of right to convey. This covenant means exactly what it says, the grantor has the legal capacity to convey title, and has the title to convey. Covenant against encumbrances. With this covenant, the grantor is assuring the grantee that there are no encumbrances against the title, other than those set forth in public record or the deed itself. Covenant of quiet enjoyment. This doesn't mean the neighbors aren't noisy, it is an assurance by the grantor that the grantee will not be disturbed in the use and enjoyment of the property because a title defect is passed on by the grantor. Covenant for further assurances. This is a promise that the grantor will provide any additional assurances that the grantee reasonably requires, and will perform any acts necessary to correct any defect in the title being conveyed. Covenant of warranty. This covenant states that the grantor will warrant and defend the title to the grantee against the lawful claims of others. It is the best form of warranty for protecting the grantee, as it contains no limits as to the possible claimants protected against. As such, it is the most important of all of the covenants. So, back to our A, B, C story. If A had sold a property to be using a warranty deed and it didn't actually own that property because it was owned by C, the deed is void because it contains assurances, covenants, that are not true. So even if C later quitclaimed the property to A, it's too late, because the original warranty deed between A and B is void. Warranty deeds are rarely used in California, as they present a bit of liability to the situation. Instead, grant deeds combined with title insurance are commonly used. Gift deed. The legal form for a gift deed is the same as for a grant deed, however the intention of the parties differs. With a gift deed, the consideration is love and affection. Gift deeds may be used in lieu of a quitclaim deed to transfer property to someone else. The deed should note that there is no consideration, or that the title is being transferred out of affection. Quitclaim deed. The quitclaim deed does not offer any warranties to the grantee. All it does is release any rights of the grantor to the property. In fact, the grantor may have no rights to begin with. The deed does not state that the grantor has any title or interest, and makes no warranties as to the quality of the title. All that is accomplished when the grantor signs the quitclaim deed is that it prevents the grantor from later claiming interest or ownership in the property. A common use for the quitclaim deed is when there is a possible heir or other person who may have an interest in the property, such as a former spouse after divorce, which creates a cloud on the title. A cloud is a question that lenders and title companies want to clear up. To remove the cloud and create a good and marketable title, the possible claimant will sign a quitclaim deed. Quitclaim deeds are also used to clear clouds that exist in the form of liens that have been paid but are not yet released, and claims of relatives after estate probation. Court-ordered deed. Some types of court-ordered deeds are the executor's deed, the sheriff's deed, and the referee's deed. The executor's deed conveys real property from a decedent's estate to a buyer. An executor can do this only if the will or court of law granted the executor this authority. The sheriff's deed or referee's deed transfer title to the winning bidder in a judicial foreclosure auction. It's important that the consideration paid is clearly stated, and that the source of the sheriff's or referee's authority to convey the property is also explicit. The only covenant it contains is that the sheriff or referee hasn't damaged the title. Court-ordered deeds must have the full consideration stated in the deed, usually because the deed is executed pursuant to a court order, and the court has authorized the sale for a specific amount of consideration, which must match what is stated in the deed. Deed of trust. This deed is used to convey property to a trustee for the beneficiary named in the deed. California uses this as its typical security instrument for a mortgage loan. With a trust deed, the title to the property is held in a trust until the loan on the property is paid in full. When obtaining financing for a real estate purchase under a trust deed, the borrower conveys title to the trustee to hold on the beneficiary's, lender's, behalf. The lender is the beneficiary of the trust. The trust deed contains terms that authorize the trustee to sell the property to repay the beneficiary if the borrower defaults. A reconveyance deed should also be mentioned here. California Civil Code Section 2941(b)(1) requires the beneficiary, when the loan is paid off, to execute and deliver to the trustee the original note, deed of trust, request for a full reconveyance. Then the trustee must execute and record the reconveyance to the beneficiary, and, if requested to do so, the original note and deed of trust to the trustor. Other deeds. Tax deed. This deed is used in a tax sale to convey title to property that the government is selling due to non-payment of taxes. Trustee's deed upon sale. Property transferred due to non-judicial foreclosure uses a trustee's deed upon sale to transfer title to the winning bidder at the foreclosure auction. The deed is recorded in the county where the property is located. It conveys full ownership, the entire bundle of rights, but doesn't include any guarantee that the title is clean. The property may have encumbrances that the new owner is now responsible for, such as tax liens or mechanics liens. Elements of a California deed. As required by the statute of frauds, every deed must be in writing. Oral conveyances are not recognized by law. It's a good thing. Can you imagine if someone said, "I trade my house for a gin and tonic," and it would stand up in court? Not pretty. In addition to the requirement that deeds be in writing, the written deed must contain a few essential elements. The required elements in a deed in California are: correct names of grantor, who must be competent to convey property, and grantee, who must be capable of receiving the grant. Act of conveyance, granting clause, including the words grant and convey or either one of these words. Complete legal description, e.g., meets and bounds or lot number with plan book volume and page number reference of the recorded subdivision, or a prior deed reference for the same property. The grantor's signature. Delivery and acceptance. Additionally, the deed must be recorded in the office for the recording of deeds in the county where the property is located, once the deed is acknowledged by the executing party. Now, let's discuss some of the deed elements in a bit more detail. Grantor/grantee. The grantor is the person conveying the title. In a typical real estate transaction, this will be the seller, who will convey the title to the property to the buyer. For the conveyance to be legal, the grantor must be of legal capacity, which means mentally competent and of the age of majority. It is also required that the grantor be specifically named and positively identified. The grantee is the person receiving title. In a typical real estate transaction, this will be the buyer, who will receive the title to the property from the seller. In contrast to the grantor, the grantee does not have to be legally competent and need not have reached the age of majority to receive title. The grantee could not, of course, turn around and convey title if they were not legally competent, but they can receive title. A person who can't grant property under the law may use a guardian's deed to do so, however. This would involve permission by the court. In a deed, the grantor is often referred to as the party of the first part, and the grantee is referred to as the party of the second part. The deed must include the addresses of the grantor and grantee. Granting clause. The granting clause includes the important words, grant and convey. These words not only express the grantor's intent, they actually transfer interest from grantor to the grantee. Other words used in granting clauses might be convey and warrant, grant or grant, bargain and sell. Within the granting clause are statements that the title is free of encumbrances, and that the grantor has not conveyed the title to anyone else. Signature of the grantor. In order to execute a legal document, one or both parties sign. To execute a deed, the grantor conveying the interest to the property must sign. It is the grantor only who executes the deed. The grantee is not required to sign unless the grantee is assuming a mortgage. For instance, with a condominium unit, a grantee will sign to indicate that the grantee is assuming the obligations of the declaration, like the constitution of the condo. Acknowledgement and recording. You can't record a deed unless it is legal and has been acknowledged. Acknowledgement is an oath of a subscribing witness, such as a notary public. The grantor must state to the notary that the signing of the deed is a voluntary act. While the deed is valid between the parties without an acknowledgement, recording is vital if the grantee wants to protect the title against future buyers of the same property from the same grantor. Therefore, the grantee should always expect to receive an acknowledged deed. A deed is typically recorded at the county clerk where the property is located. Delivery and acceptance. To effect a transfer of title by deed, delivery and acceptance must occur. The grantor must deliver a valid deed to the grantee, preferably acknowledged by a public official such as a notary, and the grantee must accept it. When these are accomplished, the title is transferred. Delivery may be made directly to the grantee, or to an agent of the grantee such as an attorney, real estate broker, or the title company issuing the title. Once delivery is made, acceptance is presumed. Who wouldn't want to accept real property? The presumption is made stronger upon the recording of the deed. Note, every real estate document that is recorded in California is subject to a $2 fee to be placed in the Real Estate Prosecution Trust Fund. These funds are distributed by the County Chief Administrative Officer to district attorneys and law enforcement agencies to be used to investigate and prosecute real estate fraud crimes.